So hi, I'm Kim and I intend to take the Philippine bar examinations this 2024. So as of recording, it's September 2023 and the upcoming bar examinations would be September next year. I want to start preparing for it already. And the purpose of this channel is to help me stay disciplined and so I will be discussing certain topics of law because I feel that it's a good exercise. I realized I learn best when I try to explain things, and who knows, you might find value in it as well. I also want to practice my English. I want to be articulate and concise. Char. I'm from Beda University College of Law, so I will be using the school's syllabus when I discuss the topics. So disclaimer, I'm not a lawyer yet. The keyword here is yet. And if I make mistakes, please do not hesitate to correct me. That way we can learn from each other. So I will be discussing criminal law in this video. So we'll start with general principles. So I made notes here so that we can stay on track. And this follows, again, the syllabus of San Beda. So general principles, the revised penal code took effect on January 1, 1932. And criminal law is that branch or division of law which defines crimes, treats of their nature, and provides for their punishment. Penal laws are those acts of legislature, meaning the criminal laws that we have in the country, they were written by Congress. So these penal laws prohibit certain acts and establish penalties for their violations. Or those that define certain acts and establishes penalties for their violations, or those that define crimes, treats of their nature, and provide for their punishment. Basically, I was just repeating the same thing, no? Ang ibig sabihin lang nito is any act actually, if the Congress wants to criminalize it, it becomes a crime. So it's really up to Congress. As long as, of course, it is not contrary to what is stated in the Constitution, because in the hierarchy of laws, of course, the Constitution remains to be the fundamental law of the land. It sits on top of there. So criminal statutes are to be strictly construed against the government and liberally in favor of the accused. Kasi nga naman, diba? If this is not the case, then the government may abuse the rights of the people. So it's a way to balance it rin. So interpretation can only be invoked if the law is ambiguous and there is doubt as to its interpretation. If the law is clear naman, there is no need to interpret it. Again, the interpreting part is the job of the judiciary. So this is political law na, no? But we'll just discuss the general principles, but then it's very important. In construing the old penal code and the RPC, the Supreme Court had accorded respect to decisions of the Supreme Court of Spain. Kasi dun binase yung revised penal code sa Spanish penal code. Or the 1850 penal code of Spain. However, this doesn't mean that when the Supreme Court interprets penal statutes, it really goes back to the penal code of Spain. It's only when there is ambiguity and when our laws are insufficient in interpreting the laws. Kumbaga, kung hindi sapat kung ano yung meron tayo, that's when they look to the Penal Code of Spain. Kasi dun galing. Pero the Penal Code of Spain only has a persuasive effect sa interpretation ng penal laws natin. Statutory construction na to. So, I won't discuss na talaga like how you interpret laws. But basically, that's it. It's our revised penal code is from the 1850 Penal Code of Spain. So, let's go to the definitions muna, no? What is a crime? A crime is an act or omission. An act meaning a positive thing that you do. An omission is something that you do not do when you should have done it. So, it is an act or omission punishable by law. Kasi nga, this certain act or omission, yung legislature, ginawa nilang crime to. So, when you commit this or when you don't do this, you commit a crime. There are acts that are very, sabihin na nating shocking to the conscience, for example, na dapat crime yan sa moral standards natin. Pero if there is no law penalizing it, it's not considered a crime. So, wala kang liability. So, discuss natin mamaya yung liability. A felony is a crime or acts and omissions punishable under the revised penal code. Crime, felony, minsan ini-interchange or offense. Pero felony, mas specific siyang term na ginagamit for crimes and omissions punishable under the RPC. Kasi not all crimes or not all penal statutes or penal provisions or not all acts or omissions that are punishable by law come from the revised penal code. We have what we call special penal laws. Wala siya sa revised penal code, pero merong batas that penalizes it as well. Ano ba yung revised penal code? Ito yung codified na siya. So, may book 1, book 2, tapos may mga articles dyan. So, pag dyan galing yung crime, then the term used is felony. Kapag ka special law naman, it's an offense. Yun yung term na ginagamit. Pero, regardless, these are just crimes. Ano lang yan, parang mga specific terminologies na pag sinabi mong offense, usually it refers to crimes punishable by special penal laws. Pag felonies naman, crimes punishable by the revised penal code. So, dun mo mahahanap na kinicriminalize yung certain act or omission. Okay. So, when you say infractions naman, usually these are violations of ordinances. So, ito yung mga city ordinance, diba? Sometimes, a certain act is a violation in, for example, Quezon City, but it's not the case in Makati, for example. So, infractions yung term. Regardless, these are all quote-unquote crimes. So, lagi nating maririnig yung mala inse, mala prohibita. When you say mala inse crimes, these are crimes that are inherently immoral. Ito yung mga murder, arson, rape. Kasi, what mala inse means, I think this is Spanish, di ba? Kasi, the revised penal code is based in the Penal Code of Spain. So, may mga Spanish terms and here and there tayong ma-encounter in the study of criminal law. So, it literally means evil in itself. So, the mens rea is defined as a guilty mind. guilty or wrongful purpose. So, merong criminal intent. And the intent is the purpose to use a particular means to effect a definite result. It is an element of a crime, except for culpable felonies, which I will discuss later. Kasi, pag culpable felonies, kahit hindi mo siya sinadya, kahit wala kang criminal intent, but if you commit it, say for example, you were negligent in doing something, it's considered as a culpable felony. So, dito sa mala insect crimes, parang inherent talaga yung pagka-evil niya, and inintend mo talaga with a criminal mind to do such act or omission. Mala prohibita, on the other hand, literally means prohibited evil. So it's not an evil in itself. It's just an evil that was prohibited because the legislature said so. It is an act that is a crime merely because it is prohibited by statute or by law. Although, hindi kailangan that the act is necessarily immoral. An example is a violation of the bouncing checks law or BP-bilang 22. So, dito, pag nag-issue ka ng cheque and tumalbog, you are criminally liable. Syempre, merong elements yan. Hindi naman yan agad-agad na pag nag-issue ka ng cheque, tumalbog, liable ka agad. Hindi naman ganun. Meron yung elements. Pero sa Crim 2 na yan. So, for now, stick tayo sa topic na general principles. But the thing is, when you write a check, it's not inherently moral. Like, what's so immoral about writing a check, diba? Nothing. So, the act of writing a check was made evil or was criminalized by Congress. So, now it's a crime. It's not just a simple act of writing a check. It's the act of writing a check na alam mong walang laman. So, parang in a way, nanggugoyo ka or nanloloko ka. Diba? So, to avoid that, ginawa siyang crime so that people don't do it. Diba? So, may reasons naman. Hindi naman yan parang huminga ka lang crime na. Hindi pwede. May limitations din naman yung Congress. Kasi meron tayong Constitution at meron tayong inherent human rights. Diba? And kailangan nating mag-comply sa international law. So, we have human rights and may, kumbaga, yes, pwedeng i-criminalize ng Congress certain acts na hindi naman immoral. Pero, meron limitations which we will discuss later. So, ganon. Sources of criminal law and its basis, the police power of the state. So, poly na to. I might discuss it in a different video. But, yun yung vested in Congress. Because of that police power, a legislature can create these laws that punishes certain acts or omissions. Diba? Ano ba pinaka-purpose ng criminal law? That is to ensure na people live in peace. Na may public order. Diba? Na merong public safety. Ganun eh. So, saan yung basis or ano yung sources ng criminal law? Yes, ultimately, Congress, sure. Pero, it's, as I've discussed before, it is found in the revised penal code and its amendments kasi na-amend na yung RPC eh. It's a very old law. But it was recently amended. And special penal laws. Special penal laws passed by the Philippine Commission, the Philippine Assembly, the Philippine Legislature. Ito yung mga dating Congress before the 1987. Ito yung Congress before, pangalan ng Congress before pa sila tinawag na Congress of the Philippines. Okay? Like National Assembly, Batasang Pambansa. Also, penal presidential decrees issued by former President Ferdinand Marcos during martial law. So, that's also still a source of criminal law. That's why merong mga crimes na violation of PD ganito. PD meaning Presidential Decree. RA meaning Republic Act. Galing yan sa Congress. So, we already touched this topic just a while ago. Limitations on the power of Congress to enact penal laws. Sure, they have plenary power to create such laws, but there are restrictions. Restrictions dahil sa Constitution, because again, the Constitution remains supreme. So, we'll discuss these constitutional limitations. Number 1, no ex post facto law or bill of attainder shall be enacted. So what is an ex post facto law? It's a penal law which is given retroactive application to the prejudice of the accused. Back then, nung first year, hindi pa ako marunong mag-aaral. And when, for example, I'm studying, minsan I would just stop at ex post facto law, penal law which is given retroactive application. Parang ganon. So, in my mind back then, pag retroactive application, bawal. Diba? Pag ang penal statute may retroactive application, hindi na pwede. But that's wrong. Again, to the prejudice of the accused. Kasi, retroactive application ng penal law is actually fine. Sometimes advantageous pa siya sa accused, which is allowed. So, pwedeng mag-enact si Congress ng penal statute na may retroactive application. Pwede. Pero bawal ang penal statute na retroactive application to the prejudice of the accused. So, yun. Ex post facto law is a law which makes criminal an act done before the passing of the law which was innocent when committed and punishes such action. Kasi unfair din naman na talaga, 'di ba? Like nung kinomit mo siya, hindi siya crime, and then after mo siya i-commit, may pinasang batas, tapos sasabihin na lahat ng gumawa niyan criminal na or liable, criminally liable. So, 'di ba? Hindi pwede 'yon kasi unfair 'yon kasi at the time that you committed the act, hindi pa siya crime. Perfectly legal pa siya. Another example of an ex post facto law is one that aggravates a crime or makes it greater than it was when committed. Same effect, 'di ba? Unfair. Changes the punishment and inflicts a greater punishment than the law annexed to the crime when it was committed, alters the legal rules of evidence, and authorizes conviction upon less or different testimony than the law required at the time of the commission of an offense, assumes to regulate civil rights and remedies only, in effect imposing penalty or deprivation of right for something which when done was lawful. Basically the same thing. Deprives a person accused of a crime some lawful protection to which he has become entitled, such as the protection of a former conviction or acquittal or proclamation of amnesty. So, may protection siya before tas tinanggalan mo. So, these things, bawal. Pwedeng prospective application, sure. Ignorance of the law excuses no one. And, alam mong mali siya, ginawa mo pa rin, diba? Pero, kapag nung time na yon hindi naman siya mali, tas ginawa mong mali, that's not fair. And that results to injustice. That's why this is not allowed. Ano naman yung Bill of Attainder? Bill of Attainder is a legislative act that inflicts punishment without a judicial trial. Again, poly, may right tayo when accused to due process. So, kung walang judicial trial, di ba, pwede kang pagbintangan lang and then you'll suffer. You'll be liable. So, hindi ito pwede. So, essential to a bill of attainder are may specific or certain individuals or group of individuals. Then, there's an imposition of a punishment, whether penal or otherwise, and there's a lack of judicial trial. Yun yung pinaka-essential element actually. Since overloaded na tayo sa info, basta bill of attainder, walang judicial trial. Diba? Pag ex post facto law, ginawang retroactive ang isang law to the prejudice of the accused. So, next constitutional prohibition or limitation on the power of Congress to enact penal laws is that no person shall be held to answer for a criminal offense without due process of law. So, kinda like bill of attainder. Then, it should not impose cruel, it meaning the Congress. The Congress should not impose cruel and unusual punishment, nor should it impose excessive fines. So, the Philippines imposed death penalty as capital punishment before. But on June 24, 2006, RA number 9346 was approved and it prohibited the imposition of death penalty. So, starting 2006, wala ng death penalty. Yung pinakamataas natin is reclusion perpetua na, pero wala nang pinapatay. Prior that, we had death penalty. Next is that no person shall be deprived of life, liberty, property without the due process of law, nor shall any person be denied the equal protection of the laws. So again, this is consti equal protection. Saglit lang. It means dapat similarly situated yung certain individuals, they should be treated the same. Hindi pwedeng i-apply mo yung penal statute to certain group of people lang or a certain person lang, pero hindi sa iba. Dapat lahat na similarly situated. So yun, yung equal protection of laws, we can discuss it even further sa another video na political law. Next is freedom of expression. So, yung Congress cannot impair freedom of expression. The guarantees of free speech and free press include the right to criticize judicial conduct. The administration of the law is a matter of vital public concern. Whether the law is wisely or badly enforced is therefore a fit subject for proper comment. If the people cannot criticize the justice of the peace or a judge, the same as any other public officer, public opinion will be effectively muzzled. So, yon. Self-explanatory na din naman na yan. Next is that Congress cannot enact penal laws that impair the people's freedom of religion. So, the Free Exercise Clause prohibits government from inhibiting religious beliefs with penalties for religious beliefs and practice. The Establishment Clause prohibits the government from inhibiting religious belief with rewards for religious beliefs and practices. So, bawal mong ipinalize yung certain religious beliefs and practices. Bawal mo rin bigyan ng favor. Diba? Of course, certain exceptions. Siyempre, if like yung ritual nila dyan, pumapatay sila ng tao, then, that's wrong. Diba? The reason is to deny the government the power to use either the carrot or the stick to influence individual religious beliefs and practices. Kasi baka pag ginawa mong crime yung certain religious practice or belief ng isang religion, para mong sinasabing mas better yung isa eh. Parang ganon. So, aside sa pinipigilan mo sila na wala naman silang ginagawang masama, diba? They're just expressing their religious beliefs. In a way, parang sinasabi mong finifavor mo tong isa. Or pag naman, may rewards ka dun sa kabila, pero yung rewards kasi hindi naman yung penal eh. Ganon din yung effect. So, bawal. Free access to the courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. So, pag crimes, okay, medyo remedial law, ire-report mo yan sa prosecutor. No? Doon ka magre-reklamo. Yung prosecutor, gobyerno yung nagbabayad dyan. Hindi mo kailangan ng pera para mag-report ng crime. I-report mo sa police, that's free. I-report mo sa prosecutor, that's also free. Kakampi mo yung gobyerno. That's why crimes, yung cases, people versus ganito. Diba? Laging versus the people. Because when you commit a crime, you're not committing a crime against an individual, even if the victim is just a single person. You are committing a crime against the entire society. Okay? Kasi threat ka sa society eh. If you kill someone, then a killer is on the loose. The accused or the killer, the murderer, might kill another person, di ba? Danger siya sa society. That's why you report the crime and then the government will be the one taking action against that person and bring him to justice. Every person shall have the right to remain silent and have competent and independent counsel. So ito naman yung rights of the accused. Para ma-ensure na hindi ka lang basta pagbintangan and na if accused ka, you have the right to defend yourself. Kasi mahirap eh. Mahirap kapag walang rights yung accused. Kakabahan ka na baka biglang natripan ka lang ng gobyerno na gawing kriminal, di ba? Or akusahan. So, ayun. Di ba? Yung bumubuo kasi sa government natin, our police officers, the prosecutor, every person, every mechanism or every institution of our justice system. If tama yung mga terms ko. Basta the point is, they're composed of people. People have, biases. People are just people. They're human. So, these rules are set in place to make sure na fair, diba? And that justice shall prevail over personal biases, over power, over influence, ganon. No person shall be imprisoned for debt or non-payment of poll tax. Obviously, how can you pay off your debt if you're in jail, diba? But, ibang naman kapag ka-estafa, for example, kasi sa estafa nanloko ka eh, diba? Iba naman kapag nag-commit ka ng malversation dyan, or ng theft, or ng plunder, diba? Iba naman yun. Pero yung utang, like the simple utang, na hindi ka naman nanloko, it's just that, you can't pay it due to circumstances, hindi ka pwedeng makulong. So, yon. And lastly, there shall be no double jeopardy. Meaning, the Congress cannot enact a law na sasabihin na okay lang na may double jeopardy. So, ano ba yung double jeopardy? Yung na-acquit ka na sa isang crime, tapos kakasuhan ka ulit of the same crime, arising from the same set of facts, arising from the same case, the same situation. So, hindi pwede yon. Once ma-acquit ka na, okay na. Hindi na pwedeng ipilit, diba? Okay. So, let's go to pro reo doctrine. In dubio pro reo means when in doubt for the accused. Penal statutes should be strictly construed against the state or government. Only when the law is ambiguous and there is doubt regarding its interpretation. So, nasabi natin to kanina. Where the law is clear and unambiguous, there is no room for the rule to apply. Hindi pa to yung pro reo doctrine na. Yun yung rule kanina, diba? Yung pro reo doctrine, sinasabi na, however, if there is ambiguity, if there is doubt, the interpretation that favors the accused shall prevail. So, yun. Kasi, meron tayong presumption of innocence. Innocent until proven guilty. And the guilt must be established beyond reasonable doubt. So, mamaya i-discuss ko yung, quantum of evidence yung tawag dyan. So, yung proof beyond reasonable doubt, it's the highest quantum of evidence. So, yun. Later we will discuss. So, kailangan ng proof of beyond reasonable doubt to convict an accused. Rule of lenity. The law applied when the court is faced with two possible interpretations of a penal statute, one that is prejudicial to the accused and another that is favorable to him. Yung i-adapt natin, of course, is what is favorable to him. Equipoise rule. It is the inculpatory facts and circumstances that are, wait lang, may typo ako sa notes ko, that are capable of two or more explanations, one of which is consistent with the innocence of the accused and the other of his guilt. Then the evidence does not fulfill the test of moral certainty, therefore it is not sufficient to produce a conviction. So dito ka. Same lang din sa rule of lenity. Okay. So, let's go to more principles, no? Nullum crimen nulla pena sine lege. Hindi ko sure kung tama yung pronunciation ko ng Spanish. There is no crime when there is no law that punishes it. Ganon. Actus non facit reum nisi mensit rea. Hindi ko to memorize, pero at least familiar lang tayo, no? The act cannot be criminal unless the mind is criminal. So, ito yung consistent sa criminal intent. Pero again, we have mala prohibit the crimes that don't require a criminal mind. Actus me invito factus non est meus actus. An act done by me against my will is not my act. So, later, we will discuss ang tawag doon, agents of elements of something. Basta basically meron yang tatlong agents of para maging liable ka. So you must have freedom, you must have intent, and you must have intelligence. So yung sinasabi dito, if you're not free to act, probably because you're under compulsion of something, diba? May threat, may threat against your life, so you were forced to do this, or you had no choice but to do something, diba? Meron tayong mas madidiscuss natin yun sa mga justifying circumstances, exempting circumstances, mga ganon later. So baby steps tayo para mag-build up. Kung hindi ka free sa action mo, you didn't do it because of your own will, you won't be held liable. Malamang. Diba? El que es causa de la causa es causa del mal causado. He who is the cause of the cause is the cause of the evil cause. Basically, it says that kung sino yung gumawa ng crime, siya yung liable. I mean, diba? Like, if one killed someone, why would I be liable for one's actions? Diba? I could be a bystander lang, diba? So, yung actor talaga, yun siya yung magiging liable. Hindi mo pwedeng ipasa yung criminal liability mo sa ibang tao and sabihin mo na, for example, your child or your parent, committed a crime, and then you say, no, I'll take his place and I'll take the liability instead. Just free him. I'll serve the punishment. No, you can't do that. Okay, so should we discuss a case? Yeah, we can. Practice. So, one case sa syllabus ng San Beda is Ayant versus Tullet Prebon. Basically, this case discusses the rule of lenity. Again, the rule of lenity is when the court is faced with, again, two possible interpretations, one that is prejudicial to the accused and the other is favorable to the accused. Dito tayo sa favorable to the accused or more lenient to the accused. Kasi yung nangyari dito, hindi ko na sobrang i-discuss talaga yung case. Bale, yung tradition group, mga companies na engaged in I think securities or selling securities or investments, ganon. Basta hindi financial institutions, parang business na involved sa mga investments, financing, ganon, basta mga ganon. Okay, so masyado na tayong nag-nitpick sa ganyan, no? Hindi naman kailangan. Anyway, gusto nila mag-expand sa Pilipinas. And yung kabila naman, yung Tullet, okay, yung isang company, so meron tayong Tradition, meron tayong Tullet. Okay? So, yung Tradition gustong pumasok sa Pilipinas. Si Tullet nandito na sa Pilipinas. Established na siya dito. Dalawang companies, multinational. Meron silang branches all over the world. Nauna lang mag-establish ng branch dito si Tullet Prebon, yung pangalan ng company. Tradition gustong pasukin, yung ginawa, yung mga empleyado ni Tullet Prebon, kinuha ni Tradition. Pina-resign dun. Nagkaroon ng massive resignation dun sa kabila, diba? Tapos, involved yung mga directors at executives ni Tradition dun sa mass resignation. To the prejudice of, Tullet Prebon pala. To the prejudice of Tullet Prebon. Nagsilipat sila kay Tradition. So, ayun, nagkasuhan ng yung ini-invoke ni Tullet Prebon is violation ng corporation code against sa mga directors and executives nila na tingin nila nag-orchestrate ng mass resignation dito na lumipat kay Tradition. Ganon. So, yung issue dito or yung question dito is nag-invoke sila kasi ng section sa corporation code whether penal statute ba yan, yung provisions ng corporation code, ng revised corporation code. And the court ruled na, di ba, merong ambiguity na hindi. Okay? Don't treat it as a penal statute because, applying the rule of lenity, hindi. May mga specific details pa yan. So, hindi ko na i-discuss. Yung main doctrine lang na in-apply yung rule of lenity dito. Hindi tinreat as special penal law yung provisions ng revised corporation code. Ganon. Ano pa yung mga interesting cases dito? People versus Abilong. Merong confusion dito sa paggamit ng term na destiero. So, the Supreme Court resorted to the Spanish text to interpret the meaning of destiero. What else? I'm not gonna discuss everything sa syllabus. Just the important things para may example lang tayo sa concepts discussed earlier. Okay. Yung anti-hazing law sa case na Dungo versus People, it's mala prohibita. Kasi may mga provisions dyan. Hindi mismo yung may mga provisions, may mga acts doon na criminalized. Like, for example, pag andun ka lang, if present ka doon, ganito, ganyan. And malaprohibita siya. It doesn't have to be inherently immoral. No? There are violations there in RA 8049 that are mala prohibita. Meaning, may liability kan agad if you do a certain act. Okay. So, I guess that's it for the general principles. For the next video, I'll be discussing characteristics of criminal law. So, tagal no? Like 40 minutes na ako nagsasalita on such a short topic. Pero, I hope this helps. Because it really helped me, review. So, thank you.